My name is Marcus Harris. I'm a Chicago-based software and intellectual property attorney. My office develops intellectual property protection programs for clients based in the United States and internationally. Now, one of the questions that we get asked on a regular basis in our practice is, what is the trademark application process and what does it involve? And I think before you can answer that question, you've really got to ask a more fundamental question. That is, what is the process for selecting an appropriate trademark for registration? Now, the first step is to select a potential trademark that is capable of functioning as a trademark. Now, strong trademark candidates include marks that are fanciful, arbitrary, or suggestive, and the strongest of these being fanciful trademarks, and these are marks that typically don't have a dictionary definition, and examples of these types of marks include things like Xerox, Rolex, or Kleenex. Now, weaker candidates for trademark protection include marks that are descriptive, and these are marks that are descriptive of the goods or services with which they are used, and they're generally not registrable without a showing of what's called secondary meaning. And secondary meaning is simply a showing to the trademark office that that mark is perceived by the public as a source identifier rather than as a descriptive moniker. Now, in our practice, it is typical for clients to come to us with potential trademarks that are descriptive of the goods or services with which they are used, with the mistaken belief that those types of trademarks make good candidates for registration. And from a legal perspective, it really just is not the case. Now, you will spend more money prosecuting the trademark application of a descriptive mark, and you will spend more money protecting that mark from third-party use and third-party infringement over the life cycle of that trademark than you would if you had selected a stronger trademark, a fanciful, suggestive, or arbitrary trademark rather than a descriptive trademark. Now, once you have selected a strong candidate for trademark protection, you're typically going to want to conduct a search, and the first type of search you're going to want to conduct is a screening search of the Federal Trademark Database, simply to make a determination as to whether that trademark is available. Once you've done that, you almost always want to conduct a more comprehensive trademark search. And this is a search of the Federal Trademark Database, state trademark databases, and common law sources, looking for foreign language equivalents, phonetic equivalents, and really getting into the prosecution history of the marks that are cited in that trademark search to look for any potential issues or conflicts that may arise. Now, this comprehensive trademark search is the type of search that's going to allow your attorney to predict potential roadblocks to the registration of your trademark, and then to draft that trademark application in such a way as to try to minimize potential conflicts or issues or rejections of the trademark application through that process. If you have any questions about any of the issues in this video or any of our other videos, please feel free to give our office a call at 312-263-0570. Thank you.